So happy to have Moira Meltzer-Cohen and Pat Handlin. Julie Repp will be joining us shortly. Just a couple of tech issues are preventing us from having her with us this very minute. So I think we'll go ahead and I will get started just with the introductions. Pat Handlin is a criminal defense and civil attorney based in Chicago who has represented numerous water protectors facing misdemeanor charges stemming from the Standing Rock No DAPL movement. Pat spent time staffing the legal tent at Untitled camp in winter 2016 and continued as an active pro-hoc attorney through 2019. She also provided pro bono representation in the challenge to TC Energy's permit application in South Dakota to use water for the KXL pipeline. She has been a public defender, legal services attorney, administrative law judge with the Illinois Human Rights Commission, represented Occupy Chicago activists, and has litigated to protect victims of elder abuse, neglect, and financial exploitation. She graduated from DePaul University College of Law in 1978. She's admitted to practice law in the state of Illinois and has been admitted pro hoc vitae in North Dakota, South Dakota, and Texas. Moira Meltzer-Cohen is an abolitionist, lawyer, and educator supporting people's liberation movements with a focus on advocacy for elderly and gender nonconforming persons in prison. Between 2016 and 2018, she engaged in grand jury litigation and criminal defense on behalf of people protecting land and water on the ancestral lands of the Untitled in Standing Rock, North Dakota. She has worked assiduously since 2014 to educate movements about and defend them against political repressive federal grand jury subpoenas. She graduated from the University of Michigan Residential College in 2000 with a bachelor's degree in humanities, from the University of Wisconsin-Madison in 2004 with an MS in curriculum and instruction, and from the CUNY School of Law in 2012. She is admitted to practice in the courts of the state of New York, the federal district courts of New York, and the U.S. Supreme Court. And Julianna Repp is a member of the Nez Perce tribe, is a managing attorney for the Unemployment Law Project in Spokane, Washington. Prior to this, she worked as interim chief judge of the Nez Perce Tribal Court, administrative law judge for the Colville Tribes in child support and personnel matters, staff attorney for Columbia Legal Services, and owner of the Northwest Native American Law PLLC, focusing on tribal enrollment, family law, including Indian Child Welfare Act cases, human rights, and civil rights. Ms. Repp continues to serve as a pro tem judge at Nez Perce Tribal Court and has served as a member of the Kalispel Tribal Gaming Board for over 20 years. Julie has also served as vice president of the Water Protector Legal Collective Board, which oversees policy regarding the on-the-ground legal team for Indigenous-led struggles to protect the environment and climate. She's also volunteered on the WPLC civil legal team, including time within the legal tent for the Water Protector Legal Collective at the No Dakota Access Pipeline, No DAPL Peaceful Resistance Camps at Otchetisacoin within the Standing Rock Sioux Reservation. She's a founding member and was a founding chair of the Spokane County Bar Association Indian Law Section in 2009-2010 and continues to serve on that executive board. In August 2020, Julie received the 2020 Spokane Human Rights Champion Award by the Spokane County Human Rights Task Force and the City of Spokane Human Rights Commission. So we're so pleased to have all of you here with us today. Thank you so much, Maura, Pat, and Julie for being with us. I know that Julie joined a little bit last, and I know you have a PowerPoint for us, Julie. So unless you'd like to go first, I will hand it over to Mo and then Pat, and then we can have you go, if that's okay. Oh, you're muted, sorry.
Okay, that's fine. I'm not sure I'll be able to use the PowerPoint. That would be my first time doing so with on a Zoom presentation. So we'll kind of just see how it goes. Okay, thank you.
Not a problem. Okay, all right, Maura, take it away.
Okay, so I'm Mo. I served as a staff attorney for Water Protector Legal Collective for about a year, I think. But I was in Mandan doing work with WPLC as a pro hoc vitae attorney, starting in early 2017. I initially ended up there because folks were looking for someone with expertise in representing witnesses before federal grand juries. And prior to that, I had had a lot of clients who I knew from various other protest movements who had gone out to participate in the No Dabble efforts. And I got a lot of phone calls from a lot of clients, almost all of whom were white, who were saying, you need to come out here. There's not enough lawyers. There's a lot of mass arrests. There's not enough lawyers. And I was very reluctant to do so because I, at that point, really had, I had a deep interest in, but no experience with working in that part of the country. And I had no experience working with Native communities. And it didn't feel appropriate to me. It felt like I would be parachuting in. And so I tried to provide support in some other ways. And I tried to figure out, you know, how to support people in trying to find more attorneys locally. And I did eventually agree to come out and do that grand jury defense for Steve Martinez. And once I got out there, it became really clear why it had been, or that it had been so difficult to find criminal defense attorneys in that area who were not just competent, but who were interested in really listening to Native people and to clients who had truly been wronged, not just because they had been arrested in, you know, an event where police decided to use arrest as a form of punishment and crowd control, but who had like such a deep history of just being ignored at best, I guess, by a colonial court system and all of the people who participated in it. And so, you know, I took that very seriously. And when I did start finally doing criminal defense for the water protectors, you know, I was just very aware that there were a lot of ways in which I was not entirely equipped. So I just, you know, I did a lot of listening. And I think the biggest thing that if I had one takeaway for, you know, this is a CLE on elimination of bias. And I think my biggest takeaway for white people working with, or for people from a traditionally, historically dominant group, working with anyone from a traditionally marginalized group, and in particular for white people working with Native communities, I would talk about humility and how critical it is to recognize that your law degree does not, you know, is not some kind of magical trust building mechanism. And that in fact, there are many reasons that someone with a law degree might be viewed as less trustworthy, and to just come to terms with that and spend some time with that and be okay with that. I think it's always been important to me in my practice to recognize that my clients truly are experts in their own lives and always have something to teach me, and must be really active participants in their own defense in order for that defense to be effective. But I think that that may be easier to do if you already have sort of shared background, shared values, and shared assumptions. And in a situation where you're dealing with a brutal, violent, repressive, intentionally cruel colonial system, it just becomes that much more important to understand that your clients have less than no reason to trust you, and that it's just unacceptable to go in expecting to be trusted or liked or respected, because why should you be as the representative of this colonial court system? So that's sort of the first and last thing that I would say about working as a white attorney with anyone, but particularly with Native people. And then there's a tension that follows from that I found, I guess if I had the luxury of taking a step back, I would have found it interesting. But it was not simply an intellectual exercise, right? It was real and high stakes, this tension of having many, many Native people who were being continuously in real time repressed and brutalized and undermined by police and the state, who then really felt often, not always, felt really strongly about wanting to seek to be heard, to really have their voices heard and their stories told in those colonial courts, which, oh, sorry, we're having a very big thunderstorm here. Okay. So it was a really difficult thing sometimes, because I would sometimes have this impulse to sort of think, well, look, why would you want to go to trial, right? Because it was so evident that part of the strategy of the state at Standing Rock was, in fact, to make many, many arrests with or without probable cause, with or without there having been a criminal offense committed, and to drain the movement of resources, right? And one of the biggest ways in which you can drain a social movement of resources is by holding criminal proceedings, right? And so there were often these pretrial offers made that would have, just wrapped up the case. Basically, a lot of people were offered deferred dismissals. And a lot of people were really resistant to accepting those, because they felt that it was, kind of giving up in the face of power. And it was really interesting to me and really difficult sometimes to hold space for that, and to sort of affirm people's desire to go into a system that was absolutely defined, framed, and controlled in every way at every level by people whose opinion kind of should not have mattered, to try to vindicate themselves in a system that was just designed to absolutely at every turn do the opposite. And so there were these tensions that I just had to learn to make space for. We also it was also just an extremely chaotic environment, which is not specific to working with anyone except, protesters or water protectors in an ongoing, rapidly unfolding situation. But it was a challenge often, because there were a lot of sort of different opinions about what water protection and land protection should look like, and who really spoke for the water protectors, which of course water protectors are not a coherent, cohesive, or unitary class any more than Native people writ large, right? And so I think there was a lot of tendency or impulse for various people to want to shortcut or shorthand, what was good for or wanted by the water protectors, without actually doing a lot of listening, without actually doing as much investigation as probably needed to happen. And without listening necessarily to individual clients all the time. So we were trying to learn to make systems in this really chaotic environment. Almost all of the attorneys were non-Native, not all, but many. And there was, reasonably conflict around that. And one of the things that was both that was in fact happening and an allegation that was made, you know, maybe not always in a way that was reflective of reality, was that white attorneys and white sort of administrators were tokenizing either individual Native people or the opinions of certain individual Native people or groups of Native people. And it was important. It was an important conversation to have, and it was really hard to have that conversation in such a chaotic environment. And I think it was a real shame that it didn't always happen in a super productive or loving way. Yeah, I think the last thing that I would like to talk about is when I first started working at Standing Rock, I really came to recognize that you may have noticed from my last name that I come from a culture that would probably describe itself as having a collaborative conversational process. I think people who are not from that same culture might just say that we interrupt a lot. But one of the things that I really learned as a white person doing legal work with Native people was that I needed to slow way down and really hold space for people to respond, to be thoughtful and respond in a way that felt comfortable for them. And in particular, you know, I think I worked with a lot of women and Two-Spirit people who I would say when I first started working at Standing Rock probably felt really offended and insulted by the way that I talked over them, and rightly so. You know, I think there's a real tendency for legal professionals to just generally to talk over other people. And I think that can be exacerbated by regional and cultural differences. And I think it's something that we as white people and as white attorneys and legal workers, it's absolutely incumbent upon us to be aware of that, because we cannot do that humble listening to our clients if we're talking over them. So I think that is really about all I have to say.
Thank you, Mo. We really appreciate that. And there will be time for Q&A. So there have already been some people with questions. So to the extent that folks have questions, they can still put them in the chat box and we'll read them to panelists at the end. We will continue with Pat. And you're muted, Pat, so just unmute yourself first.
Yes, I am. I'm not anymore. So really interesting to hear Mo talk about having been there. I had a somewhat different experience because I came and went. I would come in to do cases, be there for a few days and then leave, and she was there all the time. But I thought I would like set the stage a little bit for, I mean, people may already know what camp was like at Standing Rock, but so I thought I would set the stage a little bit for that, which is that I volunteered in the legal tent at the end of November, beginning of December 2016, 2017. At the time when I got there, there were 10 to 12,000 people in the camp. And that weekend after we got there, 3,000 vets arrived to protect the water protectors. So there were probably 15,000 people. And it was an absolutely amazing place. It wasn't perfect, but it was pretty incredible. Every time we would drive up to the gate, which was staffed by an Akichita, there would be one or two people and they would ask, where are you going? And we would say the legal tent, and they would say, welcome home. And I like almost tear up every time I think about it, because it was such an emotional, amazing experience. I really felt welcomed home, even though, you know, I'm not from an indigenous tribe or culture. So then we would drive into camp facing the literally hundreds of flags flying, which represented the hundreds of tribes from literally around the globe that came there. And we would go to the legal tent, and the legal tent was literally a large canvas tent. And it was very cold. And there was a huge need for legal representation, because there were more than 800, I think there were actually 841 arrests between August 2016 and late February 2017. All the lawyers in the legal tent were, and the pro hoc attorneys later were vetted by the Water Protectors Legal Collective. But there were a lot of people coming through, and there were people who were ground coordinators, fortunately, for the rest of us who weren't, like Mo and Mandan. And the responsibilities in the legal tent included know your rights training on a continual basis, jail support, keeping records of arrests, bond, court appearances, taking declarations from those on the front lines who had been injured, or about what they saw and experienced, both from a criminal and civil rights perspective. And a form had been created for the declarations, which included tribal affiliation, name, address, contact information, and other evidence had to be collected and organized. And I mean, a lot of things that are actually common to any mass arrest situation or even legal work. Confidentiality had to be carefully maintained. And that was all within the context of being aware that law enforcement was trying to infiltrate, as they always do, and that there was continuous surveillance, both by law enforcement and private security, paid for by the oil company, Energy Transfer Partners. So, and they also engaged in continuous propaganda and surveillance. Tiger Swan, former military from Afghanistan and other places, I'm sure they portrayed water protectors in the surrounding community as jihadists. They did things, they went to the extent of, they tried to propagandize law enforcement against water protectors, which actually fell on racist ground with each one of them, or most of them. But they would do things like they would have robocalls for the entire city of Bismarck, warning people to shelter in place if there was a protest planned, a prayerful, peaceful protest. And the police were already militarized in terms of equipment. But I think that those efforts by Tiger Swan on behalf of the Energy Transfer Partners increased the brutality that our clients, that the water protectors suffered. The protests were prayerful, peaceful protests. They were met with continuous brutality by law enforcement, assaults in many forms, non-lethal munitions, water cannons, tear gas, and there was brutality in the making of arrests and how people were transported to jail and at the jail, including making people strip down to one layer of clothing on frigid buses where the driver had on, heavy winter gear, and they would turn the heat off and drive people for like hours to a distant jail. Things like that were particularly focused on these individuals. And I'm sure because from a racist perspective, without a doubt. Anyway, so that was the context. That was the context at camp, and that was the context for the Pro Hoc representation. But one thing that was very different was that the camp was immersed in Lakota culture. The protests were Indigenous-led, prayerful, peaceful protests. The camp operated according to Lakota culture. There was a central fire and prayer. There was generosity. There was food. There was sage. And the legal tent itself functioned within Lakota culture. And I personally was honored and still feel honored to have had the experience of being there too. And there were many volunteers coming through like me. One day I counted 8 Indigenous women lawyers who were also tribal judges in the legal tent, which was fabulous. In the legal tent we had, because there were so many people coming through, we had daily meetings. The meeting was held in a circle. It began first with smudging, burning sage in a shell and passing it from person to person in the circle, who would each allow the smoke to move around them to cleanse each individual and the space. Then a traditional prayer was said by the eldest Indigenous woman there. And then we went around the circle saying our names, where we were from, and our preferred pronoun. It was the first time I was ever asked to say what my preferred pronoun was. And anyway, so the legal tent was a place where a lot of trauma was talked about, but there was always food. Anyone who came in the door or the flap was offered food or coffee, and coffee. There was always coffee on, and the conversations sometimes as a lawyer, you know, we might rush a conversation with a client because we know what we want to know, we know what we think we need to know, and so we want to find out from them what it is, and we don't want anything extraneous because we're busy and they're busy and there's so much to do. But that did not happen in the legal tent. The conversations were not rushed. They were important. That was also part of the Lakota culture. And it was also, I mean, one thing I learned being there and being a pro hoc attorney in Mandan was that the trauma suffered at Standing Rock wasn't the only trauma suffered by the Indigenous people I represented. There is generational trauma because of the colonial genocide suffered by the Lakota and all of the tribes in the US at the hands of the US military, the US courts, the US institutions, racist settlers, some of whom settled North Dakota, the physical and cultural genocide. And it's not so far back there. It's grandparents' generation. And I would recommend that people read the interview of LaDonna Brave Bull Allard with Amy Goodman of Democracy Now! You can see it or read it because it gives you insight a little bit into the kind of ancestral trauma that's pretty recent in that land. So I learned a lot being at camp. I just being there immersed. Julie taught me how to do a declaration. I met her in the legal tent, and was like, there we were, and she told me how to do it, and so I started doing it, and I met some remarkable people. And then I will talk about having been a pro hoc attorney. So the North Dakota Supreme Court established a special pro hoc vice status. Ultimately, the chief judge of the Morton County Court tried to eliminate it, but she was not successful. And I think there were probably 32, I think there were 32 volunteer pro hoc attorneys who came and went there, in addition to the staff attorneys. And the state tried I don't know how much you need to know about how they did the trials, but they tried water protectors in arrest groups. They did chronologically, like October 10th, October 22nd, October 27th, and on. And in each arrest group, there could be as many as 200 people. So they would try them in groups of 7. And so it was important to maintain the confidentiality of each water protector in the arrest group, in preparing for trial, but at the same time to try to cooperate with other local attorneys who were representing people, because some of them were more interested in vigorous representation than others. I viewed my role as protecting, as to the extent I could, the water protectors, and that even though they were just misdemeanors, and even though they were offering pleas that could result in a deferred prosecution, it seemed really important to me to really approach each case with absolutely everything we could. So we filed a lot of motions to dismiss. And that actually turned out to be, I think, fairly important, because the cases did not have, there wasn't probable cause for most arrests. And there was a lot of information that was provided to us in discovery. There was continual aerial surveillance, which was turned over to us. It turned out that they had very sophisticated technology. They had sophisticated cameras, which I'm sure they're still using today. And they had sophisticated facial recognition technology. So they were able to, like, for example, I had a case where they used aerial surveillance and their facial recognition technology to identify a water protector in a prayerful, peaceful protest of 200 people. And they would use the booking photos to compare. Most of the clients did not have any kind of criminal background. They were young. They were clearly going to go home and be leaders in their communities. They were going to go home and be doctors or paramedics or maybe lawyers. Some of them are actually in law school. And so it was really important that they would end up in another protest, arrested potentially in another protest. So it was really important that if we could avoid a conviction of any kind or even a deferred sentence, because we know those remain on a record even though they shouldn't, it seemed important to get the cases dismissed whenever possible. Some people didn't want to come back. For some people, it was right to take the pleas that Mo mentioned. But I had the same experience that almost everyone did not want to plead guilty. And I would sometimes I had the experience of trying to talk a young Indigenous woman from Michigan into taking a deferred sentence because I was worried about her. It was a hard case and I didn't want her to suffer any ramifications from it. And so I tried so hard to talk her into it. I tried over and over again. And she said, "What will I tell my elders when I go home? How will I justify this to them? I started out doing this. I have to finish it." So that was another piece of it. And she didn't take the deal. I finally said, okay. And we went to trial and we won. And she was right. And it was, and I had to apologize to her for, putting her through what I put her through, trying to talk her into it. But the other thing that happened in North Dakota was that there was huge support from the Standing Rock Reservation. There was huge court support. Not only did people come to court every court date, there were sometimes a dozen or more people in court supporting the water protectors, or even more than a dozen. And there was often a prayer before going to court. People often brought medicine that was important to them to court. And so the Lakota culture extended to Mandan, which was a very, very racist place. I got to know some of the white local attorneys, and you know, I had the experience in the Circuit Court of Cook County because I was white. People would say racist things to me about my clients or whatever, whoever happened to be there who was non-white. I had people, white attorneys, tell me stories that appalled them about how racist really the state actually is, but Mandan in particular. So there was a jury survey done early on, which was very smart, you know, that showed us that you couldn't do a jury trial. So we did the motions to dismiss because I knew, all of us representing the water protectors knew that there wasn't probable cause for most of the arrests. And if we knew, the state knew. So that to me was prosecutorial misconduct. And the first case that I handled was ironically an arrest on Indigenous Peoples Day on the route, the pipeline route, which at that point looked like a dirt road into a field, during a ceremony of the Condor and the Eagle, which was an important ceremony. And I did a motion to dismiss. So my client and I went to court. It was the first court appearance I did there. And we went to argue the motion to dismiss. The other thing before I get there, I want to say is one thing that I did there really consistently that I think is really important, that is something else that Mo mentioned, is that I gave to my clients every bit of discovery that I got from the state. They had so much video that we would have to give them, thumb drives for them to put it on. I would make a copy for my client so they could take it home and look at it. I gave them every bit of paper. I gave them every motion before it was filed, every order that was entered. And that was hard if somebody didn't have internet or good internet. Most people did, but then it got mailed to them. And so that was a really important part of working together. So at that point, when I argued the motion to dismiss, the state's attorney thought the judge, from what the questions, was going to dismiss the charges. So he asked to speak to me in the hallway. So he said, look, I'll let your client plead to a deferred prosecution. But if he doesn't, I'm going to dismiss. I'm going to file charges at a higher class of charges. I'm going to have a warrant issued for his arrest, and I'm going to do that with every other member of that arrest group. So my client had a tough choice. What do I do? But he ended up not pleading, and we ended up winning all of those cases on motions to dismiss. We had to file another motion, but that was the kind of prosecutorial misconduct that the state engaged in, threatening people with misdemeanor warrants when that wasn't the practice there. I included that in the motion to dismiss the next set of charges. I didn't really expect the judge to grant it, but I did it because I wanted the judge and my client to know, that we were going to fight it, to know what happened. My client knew what happened. So then, where are we? Sorry. Anyway, so then treaty rights. So this is the other important thing, is that in that case, I didn't include a treaty rights argument because our clients were arrested in what's called unceded territory that was originally part of the reservation, the Great Sioux Nation's reservation. And they had every right to be where they were under the treaty rights when they were arrested for criminal trespass. And so I went at the National Lawyers Guild Convention in Washington, D.C. I went to a meeting of the Water Protectors Legal Collective, and I don't remember what other committees, probably several other NLG committees. a lawyer, and Michelle Cook, who's now on the board of Water Protectors Legal Collective, said, file treaty rights claims at every opportunity, in every case. Every opportunity you have to file a treaty rights claim, do it. And I realized it clicked. So I started doing it, and got an argument from another attorney, because I didn't know that law, and I learned it. I mean, I knew it to some degree, but I included that argument in going forward. And then the first time I included it, the judge, there were other arguments as well. The judge dismissed the case. I argued it. He dismissed the case. He didn't mention the treaty rights argument, but he did dismiss the case. And that was so important. It was so important to my client. And it was actually, I think, an important challenge overall to be presented in those particular courts, and I mean, there's a lot of interesting North Dakota law too, but I won't go into that. But anyway, the last 50 cases were warrants. Most of them were warrants for failure to appear. There were 92 or 94, and we were able to bring in a lot of people to appear and deal with their cases, because we were worried that, down the line, when the Water Protectors Legal Collective was no longer there representing people, that somebody would get arrested for a warrant, it would be bad for them. So the last 50, Mo and the rest of the Pro Hoc attorneys and the other staff attorneys were so successful that the chief judge ultimately ordered the state for the last 50 charges to file a written pleading indicating whether or not they had a good faith basis to proceed. And if they didn't, they were ordered to dismiss the case, or the judge indicated she would, within a time period, dismiss the case. And that was extraordinary, actually. But anyway, for me, it was an honor. It was an honor to be there. It was, I knew about the Trail of Tears from childhood. In law school, I read the US Supreme Court treaty rights decisions chronologically from the beginning to the mid-70s, which is a shocking and appalling experience and a great lesson. And I highly recommend taking the time to do it if you have the time. But that is far different from having a grandmother who was present as a child at the Whitestone Massacre, or a grandparent who fought in the Battle of Greasy Grass, and or having been taken from your family to a boarding school and not allowed to speak your language. But the fact remains, they survived. These nations, these tribes are nations, survived. They're sacred people, powerful people, a resilient people. And going forward, I've learned about sacred sites. I've learned some aspects of history and culture, more than I knew when I went to camp at Standing Rock. But I know so little. And so going forward, and I think this is really important, that in the context of tribal law or representation of indigenous people, I will always, and it is necessarily, seek guidance from an indigenous person of that tribe, lawyer or non-lawyer, but will look to them for guidance in the representation that I provide, because I am not part of the culture and know so little. But there, the other thing I've learned is that the nations survived. They have officials, tribal government, and the tribal government, the system of governance, is not the same as the colonial courts necessarily. So that's another thing to keep in mind when you're dealing with indigenous clients, is that they may come from a different system of governance. certainly different religion, language, and culture. But I have learned a great deal about colonialism, and that is important to apply going forward also. Okay, that's it.
Thanks so much, Pat. You know, I think that we could probably be here for days if we keep talking about some of the reflections on lessons learned from Standing Rock. And I think that the experiences, I was not personally there. I was here and gotten back, but from being abroad. But I do think that everyone I speak to that was at camp has a very unique experience. And it is often based on, and we talk about this kind of when we're talking about movement lawyering and what it means to be a movement lawyer, and you know how identity plays a role within that as well. So thank you so much to you as well for sharing those reflections with us. And Julie, we're super excited to have you here on this panel as well, because you were one of those women that Pat was talking about, one of the tribal judges and one of the lawyers that went out to Standing Rock. And even though you were not from the Lakota culture, it was a calling that you also felt. So I will let you take it away, Julie. Thank you so much for being here.
Thank you. Thanks for having me present today. I had a PowerPoint, but I'm not going to risk trying to upload it here because I'm really not technologically savvy. So I'm just gonna kind of go over some of it. Pat covered some of what I wanted to talk about, but I've got, let me go here. I'll just give a few brief observations of my time in camp. It brings back a lot of memories just hearing Pat talk about the legal tent. It was such a chaotic time, but at the time it didn't seem chaotic. I don't know how to put that in words. There were so many people and there was so much going on all the time. But we always started our legal team meetings in the tent with a prayer. We would smudge, we would say a prayer, and we would ask the Creator to help us start the day in a good way, that we did right by all the people that came into the tent and did good work for them. It was a strange dichotomy for me to be there as an Indigenous attorney because, I was in the legal tent. Really, I was not admitted to practice in North Dakota. I was admitted at the time in Idaho and Washington. I've since waiting or put my Idaho bar license just kind of on hold for right now. I may go back and practice there later, but so it was really interesting. We were limited in some of the ways that we could advise people, but we had great attorneys there that would come in and help, attorneys from the area. Not a lot of attorneys in the area. There were a few that would come and help, but it was different every day. Some days I would go into the legal tent. I made 4 trips there over, I think from the end of October through the end, or maybe the end of February. I made 4 separate trips, and each one was really unique. But during my time at camp in the legal tent, it seemed like each day was totally different. Some days we would have 4 or 5 attorneys in there, and there were times we had, I think, 12 attorneys in there. We had an RV parked next to that, which some of the attorneys worked in at times. During the weather changes, we would, if it got cold, we would have to maybe meet in the car if we had a car there, or meet in the RV. We ended up setting up, I remember we ended up kind of breaking down the tent into little offices by putting up blankets. At one time, we had to try to make separate quarters for separate meeting areas for all of our all of the water protectors, and so we had to make do with what we could. But yeah, it was there. There's just so much, and so much comes flooding back each time I think about it and talk about it, that it's just really incredible. I ended up becoming admitted to the Standing Rock Tribal Court. I didn't take any cases there ever, but At one point, I thought due to some of the arrests over in the Rosebud Camp area, which I believe was within the reservation boundaries, there may have been some cases prosecuted there, and actually there were not. But that was an interesting experience too. I never, unfortunately, got to practice, like I said, but just going in and becoming admitted to practice there was interesting. I looked at becoming admitted pro hoc vici because, again, we had so many water protectors, over 800 that were arrested, and so many attorneys, well, like myself, were not admitted to practice there. There were attorneys in Mandan, Chad Nolan, other attorneys that were very helpful. Just even Chad, I remember, would come into camp and bring us coffee at Starbucks, or was that Caribou Coffee, I think. Caribou Coffee, treats that we didn't regularly get in camp, and treats like urban natives that like me are used to, and I wasn't used to being away from those sort of luxuries. Anyway, so we had, it was an amazing experience. There were, of course, so many memories. Again, now I'm kind of losing my train of thought. Pat mentioned the pro hoc vici attorneys. Again, some of the attorneys, it seemed like, and I did go into Mandan at times, and I found, when I go into town from camp, we'd have these big snow boots on and maybe a ribbon skirt over, or over our snow pants, and a big coat. So people knew, and especially if we look native, they would know. And I had some rude comments and some rude looks, nothing, that, alarmed me more than the whole experience of being there with the police and everything. But so there was this racist overtone there. I felt the presence. I felt it when I would dress differently, when, I'd go into Bismarck or Mandan. I'm used to being able to wear like a Pendleton coat here in the winter, and there it sort of made me more visible, I think, to the general non-native population, especially those that were a little more prone to racism and didn't want us water terrorists, as I was called in one instance. There in the state of North Dakota, they wanted us to go home, to leave. And so, yeah, a whole bunch of memories are coming, flooding back. I didn't take any cases there. I know that Pat and others from the National Lawyers Guild did, and other, I think, local attorneys. So I'm really grateful to them for doing that, stepping up. I had to come back, and kind of get back into my law practice, but I was really excited and honored and happy to make the 4 trips that I did. Each one was unique. Each one gave me different experiences, and I learned more and more each time I went to North Dakota about the culture, about the legal issues, about the people in general, about the cause, the No DAPL cause. So they were all different. Again, I don't know. I tell some of my friends that ask, what made you go? They ask me, what made you go? And I just said, like everybody else there, I felt a calling. It was sort of like that Rolling Stones lyric that, or song, Wild Horses Couldn't Drag Me Away. That's what it was like for me to go there. And that's what it was like for me to leave. Every time I had to leave, I didn't want to leave. And so I would go home, get some more gear, get healthy, because I came home pretty sick a couple times, and then go back and work some more. But just, some of the considerations that I came to know and respect, especially as an Indigenous person going into the Lakota camp, the Moira-Meltzer-Cohen, I didn't know anything about, or I knew some about the Lakota culture, but not much. And so one of the big considerations is to respect the culture, and I saw that most people did, but there were some people that would come into camp and and non-native people, white people, would do that at times, feel like they could explain things or they knew what was going on better than other people. And so I would at times speak up and ask them to defer to the Lakota people, because even myself coming in as an Nez Perce tribal member, that wasn't my land, that wasn't my place. I was there to support the Lakota people, the Standing Rock. And so when I went there, it was with that in mind always, and to respect their ways, which were different than my ways in some manners. But that, there was the signs that were out front, no alcohol, no firearms, things like that, that, we were asked to respect all of those rules. Of course, we did in the legal tent, but I know there were some people on occasion who did not. But the camp leaders, generally, who were all, I believe, Standing Rock, would give culture training for those that were new to camp. And so there was these orientations for individuals that came into camp, and you were supposed to attend them. I don't know, I think they were all day, but anyway, they would generally go over the Lakota culture, their traditions, their ways. For instance, especially for those people who came into camp who maybe didn't have any cultural awareness of Indigenous cultures. One thing that was stressed early on is to know who the leaders are in the camp, that you should know who the leaders are. And if you don't know, you could ask. So there would be, on occasion, there would be some gatherings, either around the sacred fire or at other places. And so individuals would talk, and there were other rules that the Lakota or the Standing Rock would make sure that the camp participants, the water protectors, especially non-indigenous water protectors, would know, and that's to respect elders, to not record the ceremonies. The ceremonies were sacred, and so they did not want those blasted all over Facebook. They wanted to make sure that if an elder was speaking, they were not interrupted. Those sort of rules. We generally, again, they had asked at one point for those of us that were in camp to conduct ourselves in a way to comport with their ceremonies, and that's to act in a good way, to not be violent, to be peaceful, to be prayerful, and to always keep that in mind. Again, there was, I can't remember, I think it was Mo that mentioned the humility. So there was even much humility for anybody, for any of us. And I was especially humbled just having the honor to work with many of these water protectors that would come into the legal tent. They came from all over, many countless tribes, maybe non-tribal people, but I was always amazed at their, just at their spirit to help the Standing Rock. They were there, they came from all over. Some of them came in at times and wanted to know if we could draft wills for them, because people came, especially the Indigenous people that led this movement, came and they were prepared to give their life for this cause. And that was really, it was very emotional for me to think about at times. But there were, as Pat mentioned, thousands of people that came, and so I was surprised at times there was such order in the camp. In a way, I mean, it was like there were so many people that came. There were electricians and construction workers, veterinarians came to help the horses and the dogs, the pets, doctors, medics. Everybody came, everybody had a role, everybody had a purpose. And from the person that came into the legal tent that would come in and help keep our fire going in the winter, or the, I'm trying to remember his name now, the young man in the legal tent who would stay there. He would stay in the back of the tent by the kitchen to help protect the files overnight. So everybody had a purpose. Everybody, no one was on a higher level than anyone else. Everybody was there to further the cause. And so I thought, as far as in general, it just seemed like there was so much spirituality within the camp and the people. There was no, I never observed any violence, any even among the even our egos among the attorneys in the legal tent, because attorneys often come with big egos, but we like to, sometimes we feel like we know something better than other people, but we were all focused on learning about our clients, getting them to tell their stories. As Pat mentioned, we would take declarations, we would write their stories. I remember on one occasion, one Lakota came in, and he had been to the front line several times, and he had been hit with rubber bullets and pepper sprayed and mace, and had water cannons splashed on him, and he came in to tell his story, and he was it was just working through some of what he had been through. But he came in three separate days, because it was so intense what he had to talk about and what he had to express for us to get that in his declaration. He saw women on the front line get hit, and that was very, very difficult for him to discuss. And culturally, and just as a kind human being, it was difficult for him to express his emotion at watching people, women, go to the front line to pray and sing, and to be blasted with all of the atrocities that they were faced with when they went to the front lines. So yeah, it's there's a lot that I could talk about, and there's more and more that comes flooding back each time I think about it. Getting back to the legal tents, and who came into the legal tents, or legal tent. As Pat mentioned, we had volunteers from everywhere. They should be vetted. We tried to vet them. We had them sign, just as tips for future movement lawyers, we had them sign confidentiality agreements. We trained them. We tried to make sure they attended the cultural training. Tried to make sure they became aware of the camp rules, how to contact security, how to contact a medic if necessary, that sort of thing. One thing that I observed early on my first trip, as the attorneys started coming in from all over, some were from, their Amnesty International, National Lawyers Guild, ACLU. So these attorneys were coming in from everywhere. And so we tried to vet them, and then, then there would be more and more coming in. They would want to help. And so you always try to vet them. That's what we did. Want to make sure they're also, again, if they came into the legal tent, that maybe their heart was in the right place, but they had a little bit of arrogance. And we had to speak with a couple on occasion to leave the arrogance back at the hotel or wherever they're staying, because that didn't have any place at this camp or with this movement. So I would always encourage the camps, whoever establishes the legal tent, whoever starts working on legal representation, to partner with attorneys and legal organizations with experience in mass defense, civil rights, and human rights litigation when possible. So Pat mentioned some of the other things I was going to discuss. Let's see. So we developed forms. I think that was mostly from the National Lawyers Guild, based on some of their mass defense. It's a consideration when you're looking at setting up a legal tent or representation. Prepare representation agreements. Potentially, they may look different depending on what you're doing. You also have to, of course, make considerations like safeguarding documents and files, implementing methods to secure, send and receive documents. We had generators, and so we had sporadic, when it wasn't being interrupted by all the planes and helicopters and everything, we would have sporadic internet. We were never quite sure how secure it was. We used some secure communication methods, and so I think that helped. But one thing that really is critical also that we ended up working on, and Pat and others who did the criminal representation would know more about this, but we had to develop methods to preserve potential evidence and make sure that chain of evidence was secure. So those are considerations, just setting up a legal tent and doing movement lawyering within a resistance camp. We had file cabinets. I don't remember if they were fireproof or not. I think they were. I remember being concerned a time or two that the camp would be raided, and we were, had considered at times moving those files off site. One thing we always had to be cognizant of also is because we had someone sleeping in the legal tent at night, but you always have people coming and going in the legal tent, so you really want to try to secure an area that's just specific for legal files and really limit access to that area. Let's see. I already, excuse me, I already talked about meeting in other secure locations, so. I'm looking at some of these model rules, which I didn't think I wanted to bring up after all with this ABA model rules. Some of the considerations that I had as an attorney, where at times people would come to me, I'm sure others at camp, and they would have these concerns. There was a lot of stress. There was a lot of trauma. There was some, it was very stressful for some people. It was, I mean, just witnessing some of the things that they witnessed, and it was traumatic for many of us too, in many ways, that had to document that trauma. But if we had someone come to us that needed, let's say, needed some help, I'm looking at a model rule that says, and I'm not going to cite the rule, but at times we had to refer. I had a woman that I worked with, and she needed some mental health counseling, and so we always had to be cognizant of the fact that even though we weren't admitted to practice law in that state, that we still were advisors in the law and moral advisors, and so that when there would be issues that came to us, such as if someone needed mental health counseling, that we would refer them to the appropriate people to help them, because again, we were a camp and we were a community. And we always tried to make sure that we kept everyone's best interests in mind. I don't know what else to discuss. I'm just kind of free association of thought here.
Well, we definitely have questions for you all that are popping up in the chat box.
Okay.
So
yeah, I think that's it for me right now. Just as Pat mentioned, it was an incredible experience. I felt even the presence there. I felt like a lot of the indigenous people that went there. I felt the presence of probably thousands of ancestors behind me, and I felt the presence of Sitting Bull throughout the whole area there whenever I traveled anywhere. So it was very spiritual. It was probably one of the most spiritual experiences of my life. But yeah, that's probably all the comments I have for now, though. Thank you.
Thanks so much, Julie and Mo and Pat. So we do have some questions for all of you. I'm going to go ahead and read them all just because we have about 20-25 minutes left for the panel, and then we'll wrap up. So we have from Emily Beck. I'm interested in what white legal worker accomplices like me who are not attorneys can do better to support Indigenous communities. With experience in Ferguson, my hometown, and other protest spaces, I worry that what we're learning isn't being shared in helpful ways, or that we're not promoting Indigenous sovereignty and autonomy as we ought to in this work. There is another question that we have that says, how did you all, or how do we as advocates, hold space for trauma? Another question related to trauma. As attorneys, law students, and or legal workers, what do you do to stay healthy and find balance from the trauma and stress of being in such difficult spaces? From Shelby Renee Ward, what are the panelists' thoughts about the importance of having American Indian law courses in U.S. law schools as a part of the curriculum. The law school near me has an ongoing petition to have American Indian law as a standing course at the institution. And I believe finally from Chad Nodland, I want to thank the three of you, not just for the work you did in North Dakota, but also for just being who you are. My question though is this: how often do you experience memories or flashbacks of events you experienced while working in camp or in court in Mandan or Bismarck? And what do you take away from those memories? Are they positive or negative or both? And those are all of our questions, and just feel free to spitball. Just make sure you're unmuted.
So I would like to say to Chad was the lawyer who, from Mandan, who represented water protectors early on, and the state's attorney tried to introduce a photograph that had been taken from aerial surveillance without introducing the aerial video, and Chad noticed that it was a screenshot, and he was the one responsible for, the attorney responsible for forcing the state's attorney to turn over all of those like gigabytes of data of aerial surveillance. So thank you, Chad. I should let somebody else answer that question. I think I took a lot of time. Julie?
You're muted, Julie. Just make sure to unmute.
Still not super Zoom savvy. Thank you, Chad. You're thanking us. Thank you for everything you did. And like I said, even those Starbucks bagels and coffee and caribou, those were a treat, and we were so excited to see those when we could, or when you brought them in and we could have a nice little treat like that. I don't know about memories. I have more come back. I had I think I went through probably a year and a half, maybe 2 years before I really started processing everything, because as you know, it's so much when you're there. I mean, there's just so much, and it comes back little by little. And when we had recently, when we had a water legal collective board meeting in New Mexico, I mean, I had tears because I hadn't seen like Pat since camp. I hadn't seen, I don't think I'd seen Rachel. So it was just like all these people, and then they were in Holly. And so I had, I was just seeing them for the first time. And then I was remembering the last time I saw them in person, because we've seen each other on Zoom, but that's not the same thing. So I'm still processing a lot of that, I think. And let's see what the rest of your question is. What do I take away from those memories? Well, like I said before, I just, it was such a spiritual experience for me that it changed my life. I am so grateful that I went. And again, I don't even know. It was just not even a question when I went. It was like, maybe it was the thousands of ancestors behind me saying, go, go. I don't know, but, I'm still processing some of that. I think about the water protectors. I mean, they're the real heroes behind all this. They were the ones on the front lines. I think about all of them who came back as veterans and didn't have a welcome home. And so I always keep them in my thoughts and prayers. But I also think about us, those of us who were there, who shared a really incredible experience and did the best we could under circumstances that were not ideal. But, again, we had some great memories and some moments. I remember, what's his name's? Bruce's wife came and made fajitas for us in the legal tent once. I can't remember her name. So we had experiences like that. Chad brought us coffee. We had, others dropping off treats, and, another and my adopted niece from there, I stayed in her yurt. She would take around pizzas. We got a pizza from somewhere one night in the legal tent. So there's strange little memories like that that are, that come fleeting back. And then I also occasionally think about that one day, and I wasn't there, but I saw it on video when there was this the police lineup, the militarized lineup, and the water protectors were somewhere, and there was almost a standoff. They were praying, and then the police were there holding the line, and then this herd of buffalo came from nowhere. And I mean, it was such a spiritual thing. It's like, we're here with you in spirit, the Buffalo brothers and sisters are here. So things like that happened. Or, like I said, I went in to see, where Sitting Bull was. Some speculate he's not really buried there, some say he is, but went into Fort Yates. And so really, it didn't matter where he was buried, because I did feel his presence, or that just huge spiritual presence in the area. So my takeaway is just, I don't know, it was just an amazing experience spiritually. I continue to, pray and hope the best for the water protectors, because working with people that were so selfless, and I mean, they went through such atrocities. They went through criminal cases. They left their homes, left their families. They stayed, some of them camping in minus 20, 30 or more degree weather. So for that cause. And so, I think about them a lot, and thank them for, just having the opportunity to, work with them, and work with all the attorneys too. I think about all the wonderful attorneys like that are here that I worked with throughout my time in the legal tent. And mind you, I didn't spend near as much time as a lot of other people did, but I appreciate the time that I had. I learned a lot from everybody, and I guess that would be my takeaway. I don't even know if I answered the question, but anyway, thank you for asking.
Go ahead, Moya.
I'd like to respond. First of all, hi, Chad. I'm so delighted that you're here. I would like to respond to Emily's question about how white legal workers can be better supportive of Indigenous communities. And I think, a thing that really struck me was a conversation that I had with an Indigenous run collective when I was first in Mandan. And one of the things that someone said was like, it's nice that y'all white people are showing up and trying to be helpful, but like, let us make our own mistakes. Like, this has to be led by us, and it's not helpful, even if we make terrible mistakes, even if there are dreadful consequences, like, you must let us lead. And so what I would say is, that really stayed with me, right? And so what I would say is offer resources and not answers. I think, we are the representatives, even if we're the buffer, we're also representatives of the colonial courts. And those courts and the state do not respect Indigenous sovereignty or autonomy. And we as individual legal workers or lawyers can't sort of respect Indigenous sovereignty in a way that is meaningful or that offers any kind of like substantive redemption for all of the ways in which materially Indigenous sovereignty is not respected. But just to the extent that we as individuals have any power to respect Indigenous autonomy, I think that is a possibility in those relationships.
And I want to shout out to Emily too. Emily vetted me for WPLC. So thank you. And I hope you're doing well. I don't know. I think that the answer to that question is the same for lawyers and legal workers, which is legal workers were crucial in Mandan and in the legal tent. Most people were lawyers, but not everybody. And so the contributions I think are equal, and should be, and thank you, Emily, for what you did.
Yes, thank you, Emily. We miss you.
I'm going to weigh in actually real quick, although I'm not a panelist, but I'm moderating today. I just wanted to address Shelby's question about the importance of having American Indian law courses in U.S. law schools. I went to Arizona State University, and we have we have an amazing Indian legal program. But as part of that, federal Indian law classes are taught in some law schools, not in all law schools. I think that's a disservice to attorneys nationwide, because ultimately federal Indian law, when we're discussing federal Indian law and the body of that law, is essentially constitutional law. And they're all constitutional law cases, which Pat was talking about reading, from way back when through the 1970s. We have had just very recently even some incredible decisions, as recent as the McGirt decision that came out from the Supreme Court recently. So we have to, I think it's something that, if it doesn't exist at your law school, it's definitely something to petition for. And it's a disservice to attorneys that, if you're not, they're just not covered in constitutional law classes. And probably most con law professors, and I would venture to say even judges, do not have a good working knowledge of federal Indian law. And Julie has practiced a ton, on Indian Child Welfare Act cases. I'm sure she has war stories for days about how judges fail to really understand the contours of that area of law. I've practiced in that area of law as well. And it's incredibly frustrating to try to explain an area of law that should be, kind of common knowledge to someone that's a family court judge, that should be able to ask the very basic standard questions to ascertain whether or not there is the possibility of having an Indian child in front of them in a dependency proceeding or an adoption proceeding, which are just basic. And that goes back to the idea of how do we as attorneys, ensure that we are respecting Indigenous sovereignty? How do we ensure that these colonial courts and these colonial systems are actually providing a service to Indigenous peoples? And I mean, that's not what these colonial systems were built for, right? But we have a hammer, and that's what we've been given, so that's what we have to use. And that's a tool that we have. So I just wanted to weigh in on that question because I think it really hit close to home. I think it is something that, and to the extent that if you don't have that at your law school, there's plenty of other sort of resources if you have an interest in it. I was just telling Pat the other day, the Nutshell series is a good place to start. So the Nutshell on federal Indian law is a good place to start. I don't know if there are any other questions that we kind of didn't really address, maybe about healing trauma and how to balance that, the stress of being in such difficult spaces, because I think we're seeing that now even with Black Lives Matter and, in other movements too. Like, how do we as attorneys, as legal workers, as law students that are involved in these spaces and are wanting to participate in these spaces and as support, how did you all deal with that, those experiences from Standing Rock, and also holding that space for other people's trauma? I think that's the last question we haven't answered.
I think I do a ton of this work in a bunch of different contexts. And secondary trauma is super real. And we as attorneys, or at least most of us, are neither qualified nor authorized to act as therapists. And so sometimes I find myself saying to a client, like, I have to set a boundary here. And, doing things like I think Julie referred to, referring people out to appropriate mental health professionals. But I will tell you that one of the most useful sentences that I find myself saying probably multiple times a week is, do you want to tell me more about that? because it really opens up a space for people to just talk things through with you. So it's not particularly in the ambit of pure legal work, strictly speaking, but it is in the service of respecting your client, understanding your client's experience, and really holding space for that.
Well, I think we're 3 minutes away from our hour and a half mark, so I think we've done really great on time. From Joel Kupferman, he says, thank you three for tonight's presentation. The NLG Environmental Justice Committee applauds your vigor, dedication, and inspiration. Joel Kupferman from New York City. Judy Brower says, I took an Indian law class, Native American law at that time, at Vermont Law School with Professor Duthu, and it changed my life and my whole perspective on conservation and being an environmental attorney. I learned more in that class than any other. So yeah, thank you so much. I think we're going to wrap up here. So, unless there's any burning questions, last minute, 11th hour questions, thank you, Mo and Pat and Julie, for talking and speaking with us today. And we hope that we'll have other conversations in the future. This was just a great way to close out our 4-part webinar series from the Indigenous Peoples Rights Committee and the Environmental Human Rights Committee. Thank you to Jordan Winquist as well, who chairs the Environmental Human Rights Committee of the Guild. And just really a pleasure to have all of you here with us. And thank you to the attendees that have been with us continually. And we hope, if you have suggestions or want other webinars, we're happy to continue hosting these. We love the discussions that have really come out of all of these webinars. So please feel free to send those to me and Jordan. And thank you to everyone that tuned in from the Water Protector Legal Collective, both past, present, and future. So thank you. Have a good evening, everybody.